This is a recording of a talk on international trusts called International Trusts, Are They Still Worth Using? That I gave at the Ashworth Centre in Lincoln's Inn on the 6th of June 2023. Now, for those people who wanted to attend but weren't able to, I'm now hoping to give this presentation again in video form, so you can watch it if you want to. International trusts have, over the last decade or more, been subject to a number of direct and indirect attacks, and these have not been solely the province of domestic efforts. There has been an international proliferation of trust registration services, for example, along with tax-based reporting under mechanisms like CRS and FATCA, not to mention MDR, which may have left the impression that the use of trusts is no longer really worth doing. Now, without wishing to spoil the surprise of what's to come at the end of my talk, my view is that they are still of great utility, not only for those who've got existing structures that might be hard to exit, but also for those who are starting afresh. So, first of all, let's set out the terminology. What is an international trust? Well, there's no such thing as an international trust as a starter for 10. It means different things to different people, and I use it in different contexts all the time, differently. So there's no unified meaning, but the way I use it as a shorthand is the following. Usually what I mean is a trust with non-resident trustees. So a trust that is for tax purposes a non-UK resident trust. Sometimes I might use it to mean a trust with non-UK resident beneficiaries or settlors. Less commonly in the tax lexicon, we might use it to describe a non-English proper law trust. Now, to pause there, generally speaking, for tax purposes, it doesn't matter what the proper law of the trust is. It matters where the trustees are resident. So that in a couple of really specific circumstances that's relevant to tax, but most of the time it isn't. The other two ways that I might use this phrase, or that you might hear other people use this phrase, is trusts with non-UK situate assets, or trusts with income or gains that arise outside the UK in one form or another. So probably for decades, international trusts were viewed a little bit like a sort of the Swiss Army knife of international tax planning. And they've been utilised for a multitude of tax purposes for many, many years. If you think about how far back the anti-avoidance provisions in relation to trust structures go, you can imagine that their use goes back even further than that. And they've been used by the internationally mobile for lots of reasons, but including for non-domiciled UK residents to optimise their utilisation of the remittance basis, as an effective tool for reducing inheritance tax for non-UK domiciled individuals or those about to become UK domiciled, to hold non-UK situate assets with the potential to minimise capital gains tax and income tax in the right circumstances. And that actually could work both for UK resident and domiciled individuals and non-UK domiciled individuals as well. However, over time there's been this decline in utility of international trusts, both in the people whose circumstances merit their use, but also their benefits from a tax perspective. Due to the introduction of anti-avoidance measures, such as the transfer of assets abroad regime. Now that's probably one of the oldest anti-avoidance regimes that's still alive today, so that's not the best example. But we've also got examples like onward gift rules, Section 87, things like that. And all of those things can discourage the use of non-UK resident trusts. So the question is, what are those, in more detail, what are those reasons why we would stop using international trusts? The first biggie in the last sort of 10-ish years is the changing approach to how UK situate land is taxed. And I think that the changes in relation to taxation of gains on UK situate land is one of the biggest, most sort of significant sea changes in tax for many years now. And so what's happened with UK land? Essentially, there's just been a really big push to ensure that gains, income, or inheritance tax all attach to UK land. So, for example, we've had the introduction of the Inheritance Tax Act, Schedule A1. Now, what that does, very broadly speaking, it's an interesting topic and it's a relatively discrete piece of legislation, so do have a look at it because there's some interesting quirks in there which are obviously not on topic today. But essentially what that does is it treats sort of a structure as being transparent for UK tax purposes to the extent that that structure has as the driver of its value UK residential land. So you may well be familiar with the very common and some might say very plain vanilla planning technique whereby one would have a non-UK resident trust wholly owning all of the shares in a non-UK resident non-registered company, which would then hold UK land. Now, because the value in the trust was the shares in the company, that would be a non-UK situate asset, and all that value that essentially derived from UK land would not be taxable, would not be within the UK inheritance tax net if it was owned by a non-UK domiciled individual or was settled into a trust by an individual who at the time of settlement was non-UK domiciled. It would be excluded property. So that was very valuable. Schedule A1 has put an end to that. You can't do that now because Schedule A1 just looks straight through that sort of structure. So that's one of the changes in relation to UK situate residential property. More generally, and going further back, we had the introduction of ATED and the non-resident capital gains tax charge, and the subsequent inclusion of UK land and what are referred to as property-rich entities within the scope of capital gains tax. Now, all of these changes mean that it's much more difficult to keep UK situate land and income and gains arising from it outside of the UK tax net. And it doesn't matter if there's a trust involved or not. That's a general principle, but obviously that all of that reason why one might set up a trust for inheritance tax purposes has now gone. The next thing is the change to the treatment of non-UK domiciled individuals. Now, these are changes that have sort of developed over time, and effectively there's just been a set of measures which have been designed to just squeeze how much benefit there is from a tax perspective to being non-UK domiciled. So what these changes have done is effectively they've meant that non-UK domiciliaries living in the UK are less able to ensure that their assets, their income, their gains fall outside of UK tax. So some of the measures that have introduced this are a charge to use the remittance basis, then upping that charge and having a charge at an earlier point, and the introduction of the rules for formally domiciled residents. Broadly speaking, a formally domiciled resident is a person who was born in the UK with a UK domicile of origin, and any time that they're resident in the UK for certain tax purposes, they're treated as domiciled in the UK, whether or not they actually are, and irrespective of how long they've been here. But they're also excluded from a variety of benefits from a tax perspective, which we'll talk a little bit more about later. And those are added to an existing swathe of anti-avoidance measures. We've got transfer of assets abroad, we've got settler-interested trust regimes in relation to income and gains, and we've got charges on beneficiaries who receive what are referred to as capital payments from non-UK resident trusts. So just that tightening of that usage may just at the edges make people think, well, is a trust really what I need? We've then got increased international cooperation. This means it's increasingly easy for HMRC to learn about non-UK situate assets and income streams. And as such, one might think that the best approach is simply to avoid engaging with these complex regimes where it's almost certainly easier to get it wrong than it is to get it right. And so the best way to do that is simply to not engage a non-UK resident trust. Now, one of the problems with information exchange is that it is going to potentially expose people, companies, individuals who are trying to get things right to a variety of relatively fierce penalties because they've just not managed to navigate the UK tax regime, which is very lengthy and complex, correctly. And of course you have things like additional penalties that apply if you've failed to correct under the requirement to correct regime. You've got a longer time period in which HMRC can make an inquiry into you or assess you if it's an offshore matter. And you've got the hand in hand with this, you've got the increased usage of anti-avoidance measures. And so it's a very good thing that people can't simply evade tax by hiding money offshore. But the downside of that is that some people who are trying to do the right thing are going to find that they've been caught out with a very big tax bill without meaning to have done anything wrong. It's been a mistake. And in those circumstances, you might think, well, if I'm going to make a mistake like that, maybe I should just not bother at all. No, I don't think that's right. I think for lots of people, there's still a great deal of use for non-UK resident trusts. So who do I think they're useful for, and what reasons might people use them for? First of all, the three primary reasons given are wealth protection, succession planning, and tax mitigation. And wealth protection is sometimes sort of couched in terms of preventing creditors and family members accessing your money. So, for example, there may well be cases where people have thought a trust will protect them from a claim against an estranged spouse in the divorce courts. What you're finding increasingly in the divorce courts of lower tax jurisdictions is that they take a very dim view of that. You can look at countless judgments from Jersey and Guernsey, for example. So there isn't that sort of protection, and that's probably right. There shouldn't be that sort of protection. However, other wealth protection scenarios, such as not wanting to give control of significant property to naive or vulnerable family members, that reason to put them there, to put money into a trust, is still a very valid one. And one thing that people may wish to take into consideration is whether or not those family members might, in the medium to long term, cease to be UK resident. Because if they are going to cease to be UK resident, or there's a significant possibility of that, for example, you might have children at university in the United States. If there's a significant possibility, it may well be worth thinking about using a non-UK resident trust simply to manage that. And it's the same with succession planning. If you have a family where you say parents have made a lot of money and then their children are grown up and starting to have their own families, they may well have moved out of the UK, particularly if the parents are non-UK domiciled, so they don't necessarily originate from the UK. It may well be the case that non-UK resident trusts are useful for succession planning purposes in that way too. The privacy benefits of trusts are less now because you've got trust registration services. If that is particularly important, it's worth noting that some of the low tax jurisdictions have recently either suspended provision of information in trust registration services or have delayed introducing a registration service because of concerns around how that interacts with rights to privacy, whether they be human rights, domestic law, or other international law rights. So there's still that element, but that element is certainly being eroded. So turning to the primary element that some may be considering, which is tax efficiency. So can non-UK resident trusts still give us tax efficiency? And the answer is, as to a large extent it's always been, depends on the circumstances, but in the right circumstances they can be a fantastic vehicle just to ensure that tax is not being paid unnecessarily. And so many factors will go into choosing a jurisdiction outside of the UK, and those are going to include non-tax reasons, such as is it English speaking, or does it speak the language that the settlor or beneficiaries might do, time zones, whether or not there's an activated exchange relationship with relevant jurisdictions for CRS, that might come into it, what the double tax treaties are like. There might be a preference for an EU or a non-EU jurisdiction. All those things are going to go into it before you even start thinking about the actual tax consequences of the jurisdiction you choose. So it has to be done very carefully. But essentially, what I'm going to talk about now is why we wouldn't want such a trust in the UK. And really, the primary benefits are for non-UK domiciled settlors, or in particular, those non-UK domiciled people who are either going to become actually or deemed domicile in the UK. And there are still plenty of benefits for those people. So starting with inheritance tax. At the outset, yes, you can no longer effectively render the value of UK situate residential land non-UK situate and therefore capable of being excluded property by using a trust. However, if you have a non-UK domiciled settlor, you can still put non-UK situate property into trust before he becomes domiciled or deemed domiciled. So that's one thing you can do if you've simply got non-UK situate assets, pop them into trust before the settlor becomes domiciled or deemed domiciled in the UK, and then those assets will remain excluded property, so they shouldn't be subject to the relevant property regime, and obviously they're not going to be provided it is not a gift with reservation of benefit or similar. They shouldn't be taxable on the settlor on his death. So there's that aspect of it. And it can still be used for other assets which might be UK situate to take that value outside of being UK situate. So other than UK residential land, that still is entirely possible, particularly with sort of tangible and intangible assets. Debts are more difficult. You do still have the option of a specialty debt, though HMRC they rolled back their complete about face on guidance on specialty debts, and they've sort of come somewhere to a middle position between the old position, which was, well, all of the case law says specialty debts are situate where the document is, to, in a lot of cases they will be, but if there's security on UK land or it's otherwise associated with UK land, or say both of the debtor and the creditor are based in the UK, you might have a bit of a fight on your hands with HMRC. But in other circumstances, a specialty debt can be very useful. Now, on one point is if the non-UK resident trustee is neither is a settlor or a creditor, you might just give yourself a bit of a boost in terms of dealing with HMRC if they are either settlor or creditor in relation to a specialty debt. So there's that. So from that perspective, from an inheritance tax perspective, non-UK resident trusts still offer significant benefits, though one does have to bear in mind there's sort of been this carve-out in relation to UK residential land. So turning to income tax and capital gains tax, the general position is that UK resident settlors will remain taxed on all the trust income and gains if the trust is settlor interested. Now, you think, well, that's fine. If the settlor can't benefit from the trust, it's not settlor interested, and actually that's a relatively easy win. No, it isn't. A settlor interested trust is it's a much broader category of people who can't be interested and who must be unable to become interested in the trust as a beneficiary in order for it not to be settlor interested. And helpfully, we have a different position for capital gains tax and for income tax, as always. In relation to capital gain tax, if a settlor interested trust is one in which the settlor, their spouse, sorry, I'm trying to move my notes, or a member of their immediate family can benefit. Now, immediate family is a child of the settlor or a child of the settlor's spouse, the spouse of any of those children, a grandchild of the settlor or the settlor's spouse, the spouse of any such grandchild, a company controlled by the settlor or the settlor's spouse, any of their children's spouses, and any of their grandchildren or grandchildren's spouses, or a company associated with such company. So if any of those people can benefit from the trust for capital gains tax purposes, it will be settlor interested, with the impact that a UK resident non-domiciled settlor will be liable as if gains arising to the trust arise to him. So it's quite a significant position. The other thing to note about that is also that it isn't just a case that if they're not a beneficiary, it's not settlor interested. It must be the case that they can't become interested. And in essence, what that means is that you simply have to have them expressly, irrevocably excluded from benefit of that trust in order that it not be settlor interested. Now, one thing to remember about that is that there is a very significant benefit, which is that if the trust qualifies as a protected trust, then the settlor interested trust regime for capital gains tax purposes shouldn't apply. So before we go on to talk about that a bit more, let's just finish with the definition of settlor interested trust. For the purposes of Income Tax Trading and Other Income Act 2005, a trust is settlor interested if the property may be paid to or for the benefit of, or may become payable to or for the benefit of the settlor or their spouse. So that's a narrower definition, but the same corollary applies, namely that if the settlor or the spouse could become a beneficiary, i.e. they're not expressly irrevocably excluded from benefit, it's still settlor interested. And again, if you're a protected trust, then the regime doesn't apply. So protected trusts, which are certain non-UK resident trusts, offer very significant benefits in this respect, provided that they meet the other requirements. So where you have a non-UK domiciled UK resident settlor, there's potentially very significant benefits, but the trust has to be a protected trust. So either you need the position where the settlor can give the assets away so that you don't have a settlor interested trust, and that might give some significant benefits, or you can settle or you have a trust which comes within that protected regime. Now, the protected trust regime was introduced by Finance No. 2 Act 2017, and to a lesser or greater extent, it's sort of an antidote to the changes in the taxation of non-UK domiciliaries. And so it's what's being used a little bit to strike the balance between making sure that everybody pays their fair share of tax. Anyone who's heard me speak will probably have heard me say how much I hate the use of the word fair in the context of tax, but what I mean is the idea that people who are in the UK in the long term contribute in taxes in order to sort of compensate for the services that they use, I suppose, with the fact that we don't want wealthy non-UK domiciled individuals to leave. So while that domicile sort of, while the benefits of being non-UK domiciled have been squeezed and compressed down, there's this antidote, as I've described it, in the protected trusts regime. So broadly, its effects are the following. A UK resident foreign domiciliary qualifies for the remittance basis on their income and gains until they become deemed domicile. Trusts made by foreign domiciliaries have a protected status, and where that is the case, even before and after the settlor becomes deemed domicile, the trust income and gains are not taxed on the usual settlor interested trust rules. So those are those rules in ITOIA section 624, TCGA section 86, which is the one we've talked about in a bit of detail, and the transfer of assets abroad rules in ITA section 720. The income and gains will be taxed on distribution or receipt by beneficiaries, or on general principles, or there's a few certain sort of anti-avoidance regimes around the protected trust regime that I'm not going to talk about right now, fascinating as they are. So, the main reliefs that you get, Section 86 TCGA, that won't apply to attribute gains to the settlor as they arise. Section 624 ITOIA shouldn't apply to attribute income to the settlor as it arises. You then get some benefits in relation to those rules around children and capital payments to settlors in the settlor interested trust regime in ITOIA. Then importantly as well, the transferor charge in section 720 ITA, which is the transferor charge, so effectively the charge on a settlor, assuming it's a trust, which is what we're talking about now, shouldn't apply. And section 727, which is the capital sum charge to the extent that it applies to settlors, again, shouldn't apply. So you're getting some pretty significant benefits if you come within the protected trust regime. So how do we get within that regime? The rules apply in a capital, again, we don't have a unified terminology and a unified definition. which is frustrating and difficult, but they are broadly the same. So for capital gains tax purposes, we're looking for a gain arising in the tax year 2017-18 or later. The settlor must not have been either actually or deemed domiciled in the UK at the time the trust was settled, and he must not be a formally domiciled resident. Any trust of a formally domiciled resident, where the formally domiciled resident is the settlor, cannot qualify as a protected trust. The next requirement is that no property or income is provided directly or indirectly for the purposes of the settlement by the settlor, or by a trust of which the settlor is a beneficiary or a settlor of at the time when the settlor was actually or deemed domiciled in the UK. Now, this is called the tainting provision. And tainting is a great subject because if you contribute property, or one of the type of trusts mentioned contributes property at a time when you are domiciled or deemed domiciled in the UK, the protection is lost for the whole trust. It's not just that there's the portion of assets that were transferred don't get the protection disappears from the trust. So you have to be so careful not to taint, and it's very easy to taint. So it's not just the settlor adding more property, it's the settlor adding value to the underlying property, for example. So one example might be the settlor provides their services for free to an underlying trading company of the trust. If they'd normally get paid significantly for those services, or at all, they've arguably added value to the trust. What if they've made a lot of money through investments and they give investment advice to the trustee? They've probably added value, or they've arguably added value. Now, where the tainting comes from another trust, then the situation's even easier in regards to tainting. So I'm going to use an example with Trust A and Trust B. So Trust A is our protected trust. The settlor is a beneficiary of Trust B, and he's become domiciled or deemed domiciled. Trust B gives an interest-free loan to Trust A. We've tainted Trust A. We've tainted our protected trust because we've added value to that protected trust at a time when the settlor is UK domiciled, and that's it. So there are two things. If you have tainted, it's possible, if your circumstances are right, that you might be able to get rescission for mistake. That's possible. It's also possible that you may be able to limit the powers of the trustees of the protected trust, so in this case Trust A, so that they do not have power to receive property of any kind that taints the trust, or to enter into transactions that will result in tainting. It's not a complete solution, but it might help a little bit. So that's the capital gains tax position. Moving on as quickly as I can to the income tax position. As I've said, we've not got one unified set of rules. However, what we do have is a very similar position. So in relation to Itoya, in order to qualify, we must be talking about income that is relevant foreign income. The income must be from property originating from the settlor. When the settlement is created, the settlor is not domiciled or deemed domiciled in the UK. There is no time in the year when the settlor is actually domiciled in the UK or deemed domiciled in the UK by virtue of being a formally domiciled resident. So we can see again that exclusion for the FDRs. And then the trustees of the settlement are not UK residents, so you've got to have your non-UK resident trust, your international trust. And then you have the exact same tainting position. So it's similar, and I think part of the difference is simply because we're looking at income and capital, so it's a slightly different position. But that is the set of rules for Itoya. In relation to ITA, so transfer of assets abroad, you will be a protected trust if you've got RFI that would be RFI if it were income of the settlor. The person abroad is the trustee of a settlement, so this wouldn't apply to sort of maybe corporate arrangements that might be caught, or contractual arrangements that might be caught by the transfer of asset abroad rules, which are broader than just trusts, unlike sections 86 and 87. The trust has to be non-UK resident, and you mustn't have tainted it. So you can see that provided that you can get yourself into a protected trust situation before the settlor becomes domiciled or deemed domiciled, or you've got a trust that qualifies as being protected sort of just through the passage of time, it was settled at the right time, and that's where you need to be really careful about the tainting provisions. A non-resident trust is still a fantastic vehicle. So what I would say is the rules around non-UK resident trusts are incredibly complex, and they only seem to be getting more complex. That doesn't mean you shouldn't use them. What it means is that where you are going to use them, you should take proper advice. I hope this has been helpful. I'm delighted to re-record this talk, which, as I say, is a summary of a talk given at the Ashworth Centre in Lincoln's Inn on the 6th of June 2023. And if you missed the seminar this time, I hope you can make it to the next Old Square Tax Chambers seminar. Thank you.